Good morning. I'm John Nichols, the nation's national affairs correspondent, and I'm delighted to welcome you to our panel discussion on the U.S. Supreme Court and the courts more broadly. Uh, we meet at a time when, of course, the courts are very much in the news and in the concerns of a great many Americans. Uh, this has been true for all of our panelists for a very long time. They're not new to these issues. But it is fair to say that in the fall of 2020, the courts came center stage, actually just a moment before the fall, on September 18th, 2020, when Justice Ruth Bader Ginsburg passed away at the age of 87. Justice Ginsburg said that she hoped she would be remembered as someone who helped repair tears in her society. The reality is that the court has tremendous power to repair tears in our society, but also to make them. The court has become such a central force in society, both as an interpreter of the law and in the interpretations of many as a shaper of the law in this country, that we are required to focus on it far more seriously and far more intently than we have in the past. We happen to have a panel of people who have for many years told us that's the case, but now it is critical juncture. I'm honored to be joined today by Professor Randall Kennedy from Harvard Law School. He is the Michael R. Klein Professor of Law, author of a half dozen groundbreaking books on discrimination, race, criminal justice, and so many other issues, and a sometimes contributor to The Nation magazine, which is a great honor for us. We are also joined by the nation's justice correspondent, Elie Mystal, who writes our objection column in the magazine and has had the opportunity to object more and more loudly with every passing issue, and has emerged really nationally as one of the outspoken advocates for court reform and for looking at the Supreme Court in particular in very, very different ways. We're also joined by Nan Aaron, who, if I can take a moment of personal privilege, simply say, she's the person who taught me about the courts. And Nan is someone who I have over a very long time turned to when I had questions about a nominee for an obscure district in some part of the country far off from the attention of Washington. She, as the founder and president of the Alliance for Justice, has monitored court appointments, court issues, court fights for decades, and has really been the early warning system, if you will, the individual early warning system on when right-wing judicial activists are being nominated for court positions. She's also been an incredible advocate on issues of reproductive rights and a host of other concerns as regards the courts, and we're honored to have her with us. Finally, we're joined by Congressman Jamie Raskin. And Jamie Raskin is a former Maryland state senator, now representative from Maryland in the U.S. House of Representatives, a key member of the House Judiciary Committee. He, prior to going to Congress, was a constitutional law professor at American University's Washington College of Law and co-founded the Marshall Brennan Constitutional Literacy Project, which I sometimes wish some judges and justices might partake of, because I fear that constitutional literacy is always up for grabs. I'm going to start with Congressman Raskin. We may have him only for a relatively short amount of time because there are leadership votes in the House of Representatives. And so if we lose him, it won't be because he's given up on our discussion. It will be because, in fact, he's got to go and try and solve a few problems. Jamie, if I can call you, or Congressman, I've got here, I literally pulled it out from my shelf behind me, your book, Overruling Democracy, the Supreme Court versus the American People. And this is a book that you wrote at a time when you and I were both watching the struggles over Bush v. Gore and all the fights on whether the court might intervene in elections. And unfortunately, that's where we have to begin today. We see the President of the United States continuing to file lawsuits, recount challenges, a host of tests to the 2020 presidential election. You're an expert in this area, also an expert in politics. Tell us, Congressman Raskin, do you think the Supreme Court will intervene in the 2020 election in some way?
John, delighted to be with you and with this magnificent panel, and a special shout out to my former law professor, Randy Kennedy, who always has a very close place in my heart. Well, look, the Supreme Court is not going to be able to intervene effectively to hand this election to Donald Trump the way that it did to George W. Bush back in 2000 and Bush v. Gore. Remember, in that case, 49 states basically were settled. It all came down to Florida. It was extremely razor thin close, and Bush actually had the lead. And so it was child's work for 5 conservative justices to concoct a completely fraudulent equal protection rationale, believe it or not, to intervene to stop the manual counting of ballots in Florida. The current situation is nothing like that. First of all, they would have to reverse the counting of ballots, which are way in Joe Biden's favor. For example, I think it's more than 54,000 in Pennsylvania today, but we're talking about tens of thousands of votes. Biden is ahead everywhere. And the remarkable thing is how well, one, the boards of elections and the secretaries of state have worked to conduct fair, accurate, and honest elections. And then two, how well the trial courts have been documenting the fairness of the election against all of the fraudulent claims of voter fraud by Donald Trump and his team. So we're lucky that Rudy Giuliani is such a terrible lawyer, and that they've got such terrible lawyers on the Republican side this time, unlike back in 2000, because they really have essentially handed the election over by letting everybody see in a transparent way how clean it was and how Biden really won it. Their smart move would have been to go directly to the state legislatures, invoking all of their phony claims of fraud and chaos, and just try to get Republican majority legislatures to hand the electors to Trump. Now, they've sort of arrived at that strategy now, but it's way too late because everybody understands that they've lost in the popular vote decisively in Pennsylvania, Wisconsin, Arizona, and so on. So I don't think it's going to happen. And on the other hand, the court will undoubtedly continue the process I described in my book, which you generously held up, John, which is an assault on the underlying ingredients, the structural components of democracy in America, like dismantling the Voting Rights Act, as they did in Shelby County versus Holder in 2013 by decapitating the preclearance requirement and its coverage formula, like in Shaw versus Reno and Miller versus Johnson, dismantling and rolling back majority African American and Hispanic congressional districts, again on completely pretextual, trumped up, double standard ground. So that process will continue. And I guess I'd close simply with this thought. I think that the right-wing judicial ruling class has probably had enough of Donald Trump at this point. They're happy to see him, trot off into the distance, but they've got a 6-3 majority on the court, and the Supreme Court has returned to its historic baseline of class power and political white supremacy. And understand, the court still has a vague bit of a halo from the Warren Court period, but everybody needs to see what an exception that was in the full sweep of the Supreme Court's history. For all the way from the founding to the Civil War, the Supreme Court did nothing for anybody. In fact, it constitutionalized slavery in the Dred Scott decision, declaring the Constitution to be a white man's compact under which African Americans have no rights the white man is bound to respect. Then even after the Civil War and the Reconstruction amendments, as I learned from Professor Kennedy, the Supreme Court basically gutted the meaning of the 14th Amendment, and in Plessy v. Ferguson, 1896, constitutionalized American apartheid, Jim Crow segregation. And that lasted up until the second Reconstruction in the 1960s with, SNCC and the Civil Rights Movement and the Civil Rights Act of 64 and the Voting Rights Act of 65. And the Supreme Court at that point was generally on the side of the people in cases like Brown v. Board and Roe versus Wade and Miranda versus Arizona and the white primary cases and so on. But it lasted for a few decades. And the court then began to return to this historic pattern, with the Rehnquist court, the Berger court, the Rehnquist court, the Roberts court. And so today it's really returned to form. I mean, it's been a very right-wing reactionary institution. And that's what we got to prepare for again, because we're going to be re-entering a period of intense right-wing judicial activism as they try to dismantle any legislation that we can get going at the federal or state level to make America a freer and more equal and just society.
Thank you, Congressman Raskin. Can I, one follow-up question on that? You suggested people have to start to recognize this reality. My sense is that that is still a real struggle, that there are still an awfully lot of folks who are even now only in their transition of understanding the courts as a place of right-wing judicial activism.
Well,
and,
I was on
and that
a panel,
includes some members of Congress, to be honest.
I mean, I was on a discussion last night about the legacy of Ruth Bader Ginsburg, which was very moving because she, like Thurgood Marshall, they were basically two great champions as lawyers and as justices who helped to transform the meaning of the Equal Protection Clause in the last century and into this one. But there is this halo that the Supreme Court still kind of has as a hangover from the Warren Court period. And, our side has just got to fall out of love with the Supreme Court and with the federal judiciary. I mean, we've got to take it extremely seriously, which is what Nan Aaron does every day at the Alliance for Justice. We got to fight for it. But the court is not our friend. And, we should be teaching young people as much about the heroes in the political movements and in Congress and the state legislatures, the political leaders, as we do teach about Supreme Court heroes. I mean, remember, Justice Ginsburg, for most of her time on the Supreme Court, was a dissenter. And her great decisions people remember were, like the Lilly Ledbetter case, she was dissenting and she was blowing the whistle on right-wing jurisprudence and telling Congress what it needed to do to correct, these pinched reactionary interpretations of federal civil rights statutes.
Thank you. And Professor Kennedy, this is your former student, am I correct?
Certainly is. And
how's he doing?
I think he's doing great.
Come in a little, speak. You lean into that camera a little so we can make sure I can hear you.
Can you hear me now?
Much better. Thank you,
Good.
sir.
I want to say that for the past few years, I've been reading and listening on the radio and sometimes catching you on television. And I think you've done me proud. I think that you've been really, I mean, in all seriousness, and I think people ought to take this on board because things have been very serious. I was watching you, for instance, during the whole impeachment matter, you were speaking very clearly, calmly, you were knowledgeable, and you're bringing your values to bear. And I think that we've got some very tough times ahead. I'm sure that everybody on this panel feels a little bit relieved. I feel relieved, but I only feel a little bit relieved. We are we are still in the midst of darkness, and we've got some tough fights ahead. I'm glad to see you in the forum. I look forward to hearing from you more. And all I'd say is keep pushing. Again, you've been splendid. Keep at it.
Thank you, Randy.
That is, Professor Kennedy, coming off something that the congressman said, you had an article in October, just before the election, in The Nation magazine. It was a review, and you concluded it by saying a message really to Democrats and to progressives. Above all, they need to recognize and acknowledge that the Supreme Court is inescapably political. The key is to ensure that a judicial politics of equitable fairness prevails. And obviously that comes off a lot of what the congressman was saying there. Progressives, people who care about justice, have to kind of wrap their head around a lot of new thinking as regards the court and as regards the challenge it poses. Talk about that for a moment and give us a sense of where you think we should be thinking and how you think we might adjust and improve our approach.
Sure. First, we simply have to be realistic. I mean, realism, it seems to me, should be our watchword. So think of the way in which, as a journalistic convention, the courts are talked about. It's a journalistic convention to say that there are the political branches, the Congress, the executive branch, those are the political branches. And then there's this thing over here called the judicial branch. And the judicial branch is viewed very often as being apart from and above politics. We've got political branches of government. There's the executive branch, it's political. There's the Congress, it's political. There's the Supreme Court, it's political. We've got to get out of this notion of thinking that people who are thoroughly, they've had political careers, of course they've had political careers, and then all of a sudden they're going to go through a confirmation process, swear, and then they're going to not be political anymore. Of course they're going to be political. That's why so much attention is paid to these confirmation hearings and the whole question of who the president nominates, who the senators confirm. Personnel matter, and we should be very concerned about the type of people who are put on the courts. Those people will determine the legal system under which we live. And by the way, we shouldn't only be concerned with the Supreme Court. The Supreme Court's very important, but the Supreme Court handles maybe 100 cases a year. There's a lot of action that takes place in the lower courts. And not just, by the way, the lower federal court. The federal court's very important. People don't think about, we don't talk much about federal district court judges, the trial court judges. We don't talk much about the courts of appeal. But frankly, most cases don't go beyond the district courts or the courts of appeal. We also have to be concerned about what's going on in the state judiciary. So all of the judicial system, federal and state, thoroughly political. We need to be realistic about that.
And when you wrote that article, knowing the nation's timeline for how things get in, I suspect that you wrote that just before Justice Ginsburg died.
That's correct.
That's right. And you were urging this kind of more engaged understanding of it. Suddenly, we found ourselves in the midst of it. Talk to us a little bit about, just your observations of what occurred from the time that Justice Ginsburg passed over those next few weeks as the Republicans moved so rapidly to fill that vacancy.
Well, to tell you the truth, I think we need to have a broader scope. The fact of the matter is, what happened with Justice Ginsburg and the rush to fill her seat and the obvious hypocrisy of the Republicans, they stonewalled President Obama's nomination. It's, let's wait. And then they completely flipped with respect to with Trump's getting a vacancy to fill. That was obviously hypocritical. But you know what? I think we need to broaden things. The fact of the matter is, take a look at the confirmation hearings. I mean, the confirmation hearings are, in my view, an absolute scandal. We have people, including good people. We have people who are made to lie to the American people. They are made to lie. The senators ask questions. It's full of bad faith. The senator says to a nominee, isn't it true that judges merely interpret the law? They don't make the law, they merely interpret the law. And then the cue card, and I don't care who the nominee is, to tell you the truth, the cue card is to say, oh, that's right, judges just interpret the law. Of course they don't make the law. Well, everybody knows what the real story is. Of course, the judges are lawmakers. Of course, the judges are policymakers. They are lawmakers and policymakers in a different way. They, the language that they use, the procedures are somewhat different, but they are policymakers along with the executive, along with people in Congress. So again, realism. And the last confirmation hearing, again, it was just par for the course. I will answer a question if I think answering the question will be good for me. Now, if you ask me a question that I don't want to answer, I'm not going to answer, and I'm going to tell you that this might come before the courts. Well, Marbury versus Madison. Do you believe in judicial review? They'll all say, oh yeah, I believe in judicial review. Well, isn't that going to come before the court? So again, I think the problem has been brewing, frankly, for a long time. It's just become just so, it's become just more conspicuous with what has happened with the Trump judges. And here's another thing, and I'll end with this. A lot of people on our side, a lot of progressives, when Trump talked about, an Obama judge, and then the Chief Justice said, oh no, we just have judges. And there was a lot of people who were so angry with Donald Trump that they immediately and reflexively embraced Chief Justice Roberts. This is one time, frankly, where it seems to me that Trump actually was correct. Yes, there are Trump judges, and we will be suffering because of them for a long time in the future. There were Nixon judges. William Rehnquist was a Nixon judge. Lewis Powell was a Nixon judge. And there are Obama judges. Yes, there are. Justice Sotomayor is an Obama judge. Justice Kagan is an Obama justice. We shouldn't sort of flinch from that. That's just the realities. Let's be grown up. Let's be realistic.
That realism is, you had everybody on the panel nodding along with you here. So it is a shared view. And I always remind people that memory matters because Justice Amy Coney Barrett, who's just joined the court, if she serves as long as Ruth, she serves on the court to the age that Ruth Bader Ginsburg did, she'll be on the court till around 2060. And so there is a long arc with these justices and with all the judges that are appointed to these life appointments. If there's anybody who knows that personnel matters, that the appointments matters, it's Nan Aaron. And Nan, you again, I'd say, taught me to watch all of these nominations as they're coming up down in the district courts and even in the state courts, and to keep an eye on it. Clearly, what we talked about long ago, the idea of a right-wing experiment or of a right-wing project to fill the courts, often with very young people who would end up being there for a very long time. We see it fully realized now. Talk to us for a moment about how successful, frankly, the efforts of right-wing groups and right-wing presidents to pack the courts has been, and how we ought to think about that at this point.
Well, thank you, John, and thanks so much to the nation for holding this panel. And Ellie, I look forward to your columns all the time. They're wonderful and colorful and so smart. The right-wing project to pack the courts, and I use pack the courts, really began with a memo written by Lewis Powell in the early 1970s, when he called upon big companies, businesses, corporations around the country to begin prioritizing the courts. He knew evangelicals and various right-wing groups were focused on the courts. Lewis Powell did because Brown versus Board of Education spawned a whole lot of resistance and interest among the right wing, hard right, around the courts. But in the 1970s, both worlds, both cultures, the big business as well as hard right, came together to really change the face of the federal courts. And as Randy says, not just the Supreme Court, but lower courts as well. Ronald Reagan came in the early 1980s and ushered in a era of modern day court packing. And from that point, I would say the courts have long been the province of the right until now. And I say until now, having worked on this issue for many, many years, I have never seen progressives have galvanized around the federal courts as I've seen over the past 2 or 3 years. Hundreds, thousands of individuals came out and opposed nominees to a Second Circuit seat, a guy named Stephen Menashe. We saw thousands of people come together, hundreds of thousands, to oppose Amy Coney Barrett. A letter we submitted had the signature of, and I've never seen this before, thousands of law teachers from around the country signed a letter in opposition to Amy Coney Barrett. So the left is galvanized, which couldn't come at a better time with a new president. We are releasing today a statement calling upon the new administration to appoint judges who are not just demographically diverse, but professionally diverse, lawyers who have been on the front lines of civil rights, women's rights, public interest, plaintiffs' lawyers, public defenders. The courts should be filled with lawyers who have experience and knowledge how the law affects everyday people. So while the right has been successful, I see major changes underway, and I see senators, Democrats in the Senate who get it. And I think we'll stand up on this issue.
How important is control of the Senate?
Oh, oh, don't. It's very, very important. However, and in 2 years, we will have control of that Senate. But in the meantime, John, I think it's important to know that progressive groups have been able to work with Democratic White Houses and Republican Senates. We did that when Bill Clinton was president. We were able to get great judges on the bench when Republicans controlled the Senate during the Obama years. So I'm not saying it's easy, but I'm saying it's doable, and we will push hard.
I know you will push hard, and but I would suspect that you will be paying quite a bit of attention to the Georgia runoffs on January 5th.
Oh, yes. Oh, oh, absolutely. We're optimistic that both seats will be picked up by Democrats. We're very hopeful. It would obviously make a huge change, not just on the issue of judicial nominations, but as your panelists know, would really could give a green light for us to push ahead on court reform, ending the legislative filibuster, adding justices to the Supreme Court. It would be quite wonderful.
Well, boy, did you set up Elie Mystal well there. Because in talking about court reform, that's something that my colleague has really brought to the forefront. And this is, because I'm an old FDR fan, always believed that there was never such a thing as democratic court packing. It was actually court reform in the 1930s. But that issue was so pushed into the into the corner, to the fringe of the dialogue. And I was so thrilled in the fall of this year when Ellie stepped up and said without apology that we had to talk about expanding the court, and really opened up the whole dialogue. And so we return to you, Ellie, for a moment here. Obviously, there's still the up for grabs question of who controls the Senate and so many of these other issues. But why did you, at that point, why did you push it so hard? And why do you continue to keep teaching folks that this court can be a bigger court, that you can solve problems with appointments very quickly?
Yeah, so I've been for court reform since before it was cool.
That's right. Yes.
Like I've always thought that this was a good idea, and I've got two different arguments for it. One, this is the Nation Festival, so I will throw this bone to my progressive comrades. Like, we cannot long survive a 6-3 Republican court. There is no item on the progressive agenda that survives a 6-3 Republican court. You don't get Medicare for all. You don't get federal minimum wage. You don't get nothing with a 6-3 conservative court. So I can make the argument for court expansion, for adding Supreme Court justices on the straight vengeance line. Okay, what they did to Merrick Garland was wrong. Should not have been allowed. We got to make up for that. And if you think that what they did to Merrick Garland was okay, then what they did with Amy Coney Barrett was wrong and cannot be allowed. It should be made up for. So at least one of those two needs to be made up for. And I'm one of the only people I feel that continues to remember that Brett Kavanaugh has been accused of attempted rape, and that has not been investigated. He is an illegitimate, corrupt justice who was lied in Senate confirmation hearings in the past, and was subject to 83 ethics complaints that were thrown out because the lower court decided that it had no power to investigate and hold accountable Supreme Court justices. So that's two. So I get 2 seats just because McConnell is a bad guy. All right. Now, going forward from that, I think that you could argue that if we are literally in a world where whoever controls the Senate gets to also control the court, well, then if we can control the Senate, we can put 2 more people on, or 3 more people on, or 5 more people on. There's nothing constitutionally that stops us, and so we should do it because they did it to us. However, there's also a good reform argument. There is also a great argument for court expansion that goes beyond this tit for tat, Dems versus ours fight. And that is, when you look at our confirmation process, one of the things that I think we can all clearly say is that it is broken. Professor Kennedy just made the great point that we ask these justices to lie to us to our faces during their confirmation hearings. Because of the Supreme Court is so powerful, if you have a justice, one of these lifetime appointments that's opened up for the next 40 years to go against your agenda for the next 40 years, it is a political malpractice not to do everything you can to oppose that justice, right? It's one of the reasons why our confirmation process is so broken. The way to fix our confirmation process is to make each individual justice less important. And the way that you do that is by massively expanding the number of justices on the Supreme Court, right? So if you had a Supreme Court of 19 people, if you had a Supreme Court of 29 people, 29, not a radical number, that's how many judges are on the Ninth Circuit Court of Appeals. It would be fine for the federal for the Supreme Court to have the same amount of judges as California and Washington do, right, and Oregon. So if you had 29 justices on the Supreme Court, then the death of any one of these octogenarians, and let me tell you folks, octogenarians tend to die. That's not surprising, all right? So with the death of any one of these 80-year-old people would not be an existential crisis for the party out of power, because over the long arc of history and elections and people winning elections and losing elections and whatever, you would hope that it would balance out eventually, right? So if you add 29, if you add 20 justices, if you add 30 justices, I'd be fine with that too. What you do is decrease the power of any individual judge. And that, I think, goes a long way towards fixing our confirmation process. The last thing I'll say on this point, again, on the reform argument, is, again, to go back to something Professor Kennedy said about being realistic about what courts do. Now, a lot of people will say that what they want are more moderate, mainstream decisions from the Supreme. They don't like the extremism. Now, personally, I like extremism when it agrees with me. But I get most people, they don't want the extremism. They want center-line judicial opinions. And they think that the way to get that is to find center-line moderate judges. But let me tell you, as Nan can speak to in a lot of ways, there's no such thing as a moderate judge. There's no such thing as a center-line judge. A judge who is center on one issue that you care about might be a total whack job extremist on some other issue. I bring up Anthony Kennedy, who people think is some kind of moderate, wishy-washy hero. He's called a moderate because he broke with his party on key issues of gay rights. But Anthony Kennedy was a First Amendment absolutist, extremist, who was the principal author of Citizens United, which ruined our campaign finance laws, all right? So when you look at a judge like that, there is no moderation there. They're just people who believe what they believe, right? If you want moderate opinions, you need more justices, because writing an opinion that's going to be signed onto by 15 of my colleagues is an entirely different beast than writing an opinion that's going to be signed onto by 4 of my friends. So those are the two reform reasons for court expansion. I have, like I said, I have vengeance reasons out the wazoo.
And Ellie, if I could just quickly, one other element here too. I think you've talked about the notion that you could have a much larger court or much interaction with the circuit courts where you could have areas of specialty, right? You could have courts that could focus on parts of the law rather than having just 9 people deal with everything that comes up.
Yeah, I'm a big fan of, well, I'm a fan of 2 things. One, I'm a fan of panels, right? So if you look at the circuit court situation, what happens most of the time is that most cases are heard in a 3-judge panel chosen by random lot, which means you don't know who you're going to get in the first instance, right? Then, so the panel makes its decision, and then if the full court wants to review the case, it's called en banc. You have to have a majority of the court vote to hear the case in full. How different is that than what we have now? Right now, to get your case heard by the Supreme Court, for the Supreme Court to grant cert, I use the abbreviation because I can't actually pronounce the full word, certiorari, you only need 4 justices. You only need a minority of the judges to get your crazy wackadoodle case in front of the Supreme Court. So right now, if you've got Thomas, Alito, Kavanaugh, and Barrett, 4 crazy people, that gets your case up to the Supreme Court. If you went to a panel system, you'd have to have a majority of the circuit vote for en banc full circuit review. Even that small change would make our system more moderate, more mainstream, and less extremist.
All right. Congressman Raskin. And then I'm going to ask all of you before we go to questions from the crowd. And we have a lot of questions, so I'll ask you to be relatively focused in this response. Looking at a Supreme Court that is now clearly balanced to the right, or to the right wing, what's your biggest fear, your biggest concern about what this court might do in the next few years?
Well, I would echo Ellie. I mean, everything is going to be on the table with these people. They will complete their demolition of campaign finance law, for example, probably by striking down contribution limits. They will continue their evisceration of labor law. They might just, strike down the Voting Rights Act and the pre-clearance requirement entirely. So, I guess that my fear is what Ellie articulated, which is that we won't be able to deal with a 6-3 majority, that we're not going to find some structural way of countering that. I did want to, although I agree with everything else he said, I wanted to just dissent. I hope this is just a semantic difference from one thing when he called Justice Kennedy a First Amendment absolutist. He's certainly no First Amendment absolutist when it comes to the free speech rights of public workers or students or newspapers and magazines. I mean, he's a corporate statist. He wrote Citizens United and transformed corporations into rights-bearing political citizens of the republic. But that's very different from being a First Amendment absolutist.
Good point, Congressman. There's too much Reagan in him.
Man, Aaron, what?
I would just
Dan?
add to Jamie's brilliance, although Jamie, we're so glad to have you in the House. I would just add these judges, but, and again, going back to Professor Kennedy's point, are on the bench, particularly at these powerful courts of appeal, to frustrate everything that President-elect Joe Biden will want to be doing. They're on the court with Republicans knowing full well that Biden will want to put forward policy proposals on any number of issues. And Republicans are counting on their judges to stop him dead in their tracks so that he can't implement what hopefully will be a progressive agenda.
Nan, you, I guess it was about 5 years or maybe a little longer ago, you were in, I got to make sure I have the title right, Roe at Risk, a look at those issues. Obviously, that's got to be a fundamental concern.
It is a fundamental concern, but our view when John Roberts was nominated for Chief Justice was, this is not a justice who is going to overturn everything at once. He's going to take his time. He's an incrementalist, but don't be fooled. At the end of the day, he will take some of our most cherished rights and freedoms and liberties and eviscerate them. Roe versus Wade is an example. Do I think John Roberts is ready, set to go on overturning Roe? Not really sure. He's smart. What I do think he's going to do is whittle it away year after year so that there's really not much left to Roe versus Wade. And that's a tremendous fear. There is not one judge that has been confirmed by the Republican Senate over the past 3.5, almost 4 years, who supports Roe versus Wade. I've never seen anything like this, not even during Reagan, the 2 Bushes. Every single judge put on a district or court of appeals supports overturning Roe. I don't know that John Roberts will go there, but maybe in the end, we will have such a reduced Roe versus Wade that women, poor women, will have an exceedingly difficult time getting an abortion in this country.
Professor Kennedy, what's your biggest fear?
Well, my biggest fear is that the Supreme Court of the United States is going to is actually going to undercut what they see as the administrative state. I mean, and actually, I have to give them credit. They have really put their cards on the table. They see the New Deal as something that was on balance bad, many of them. Justice Thomas, Justice Thomas has been a very important figure. He has called the shots in certain ways. He's been ahead. Sometimes he'll be, he'll be a dissenter. He'll write a concurrence, and people won't pay a whole lot of attention. And then 3 or 4 years later, the court is taking his positions. He is very clear. In the positions he takes, he does not like the modern administrative state. So for people, for instance, who are very concerned about the problems of climate change, using the government to attack, ecological problems, there are a number of justices who are saying, oh, no, you can't do that. Well, why? Well, because in 1787, that was not what was, envisioned. Well, we can laugh and we can think, gosh, how ridiculous. But the fact of the matter is that These folks are the living Constitution. These folks are the living Constitution. And again, and it's not just them, it's not just the Supreme Court, Court of Appeals, district court judges, this idea that a activist government is actually a threat to our liberties. Think about what's going on now. Why are we talking the way we're talking? I'm happy to be here. It'd be a lot nicer, however, if we were in person. Why aren't we in person? A pandemic. Look what's been going on in the last few weeks and months. The courts standing in the way all too often of simple efforts on the part of the government to keep people safe. Appeal to the courts to strike those commonsensical efforts at protection. Courts are striking them down. Well, in the weeks and months and years to come, my fear is that those efforts will be enlarged. And even if we get a Senate that will cooperate with Biden-Harris, I mean, so far people have been optimistic. I hope that will come to pass. But even if that comes to pass, if there is not change with respect to the Supreme Court, those efforts will be struck down. Look at the fate of Obamacare. It was upheld one vote, and it has been undercut. It might be undercut even further. Well, it seems to me that that's a cautionary tale. That is why we do need reform. And I think not only in terms of judicial reform, not only in terms of reform of the personnel, I also think we need to be thinking actually more broadly. We do not have a perfect constitution. The last few years should have shown us that our constitutional regime has some big problems. Now, maybe they were hidden from us before. We didn't think about certain things. But what our experience over the past few years under Donald J. Trump as president should show us that we have some problems of a constitutional nature. We should be rethinking our Constitution. And, we should have it as sort of an experimental mind. Let's think broadly about what we want. I think it's important for us to, try to ward off what we don't want. That's very important. But I also think we should consider, what do we want? And some of the things I think that we want will require a new constitutional dispensation. So let's open up our minds. Let's be a little bit more adventurous. Let's be willing to think a bit more broadly, because frankly, I think actually thinking more broadly is prudential. Donald Trump did not just fall out of the heavens. He emerged from deep problems in American life. And to address satisfactorily those deep problems in American life is going to require us thinking anew.
Boy, I am so with you for that next Constitution. And I wish we could do a whole panel discussion on that. Perhaps the next festival we'll go there. I've got a lot of ideas about what we ought to do with the US Senate. But before we go to the questions from the crowd, and we have a lot of them, so I'm gonna give that last element to Ellie here. The thing you fear most about this court.
Yeah, just really quickly, voting rights. The thing that ties a Trump judge to a Reagan judge, to a Bush judge, is their hostility to voting rights. We are looking at, Congressman Raskin put it very nicely about how the Supreme Court will probably not throw this election to Donald Trump, but the next one. They've shown a willingness to do that. They've shown a willingness to throw away the votes, especially of people of color. So what am I worried about, John? I'm worried about political apartheid. I'm worried straight up about political apartheid being allowed by the Supreme Court by disregarding voting rights.
That is my worry as well, although I'm also very worried about something else Congressman Raskin mentioned, which is the evisceration of labor union rights. And Samuel Alito getting his long-term mission of undermining the right to organize and the right to collectively bargain. Let's go to the, oh yeah.
Forgive me, I gotta go. Let me just, if I could make one final point, which is to echo Professor Kennedy's last point about constitutional reconstruction. I mean, America really is at a crossroads here. I was hoping the election would settle the question, but it didn't. The question continues. The struggle is continuing. We can go down the road of becoming a failed state. A failed state is one that fails to deliver the basic goods of existence to the population, whether it's security against disease, security against random gun violence, security against unequal administration of the laws based on racism or sexism, security against climate change, right? But this is the road that we're on. Or we can get back on the road of interracial social progress, reconstruction. We really need a third reconstruction in America. That's the only thing that will give us the power to confront the convergent crises of our day. And that will require a thoroughgoing statutory, local, state, federal, and constitutional reconstruction of the country. So I am with all of my panelists in saying that we need to reimagine where we're going, and we need to fight for it every single day, the way that Man Aaron does. So thank you for having me, John, and I'm sending my love to the great nation audience out there.
Well, we're honored to have you, and thank you for joining us. I know you really fit it in, so we appreciate it very much. We still have about 15 minutes left, and I want to take as many of the questions from our audience as we can. One question that comes up a lot from all sorts of different folks, but I'll sum it up with Diana Echeverria, who says term limits would eliminate the huge power that an individual president has to influence the court for years just because she happened to reign during a number of vacancies. Trump is the poster boy for that problem. Is that advisable and achievable? So term limits, what do we think?
Great idea, not constitutional. I mean,
there you summed it up, brother.
The Constitution is relatively clear. The Constitution doesn't say a lot about the Supreme Court, but one of the things it does say is that the justices shall serve while in good behavior. That's been interpreted to mean that they will serve for life. Now, I think that there are some really interesting ideas to get around that. That says they'll serve for life, doesn't say they'll serve on the Supreme Court for life, so we can push them down to. I think there's some great ideas. Does John Roberts agree with me? Does John Roberts think that he should be kicked off the court before he dies? I don't think so. And if he doesn't agree with me, well, then guess what? It's unconstitutional. As Professor Kennedy said, these people are the Constitution for all intents and purposes. And so when they say your idea is unconstitutional, guess what? It's unconstitutional. It's a brilliant idea. My way of getting term limits is to, I think, and quite frankly, I don't think liberals understand how far behind we are on this question. I don't think you got more than 2 justices who are even interested in term limits. I don't think you got more than 2. So to me, if you want term limits, I have a way for you to get it. Put 10 justices on the court who agree with term limits, and then pass your term limit bill, and then all of a sudden it becomes constitutional.
Everybody else agree with Ellie on that? Essentially, all right. I happen to I read it myself as still holding out that promise of term limits. I really like that Ro Khanna has introduced a bill proposing to go into that zone, and I appreciate it. But I defer to wiser souls than I, so I'm going to go to Ben Duke here. If Professor Kennedy is right that realism should be our watchword, how does that apply to proposals for Supreme Court reform? How do you actually get any of these reforms accomplished? And I'm going to ask Professor Kennedy on that one.
Well, I think to a very large degree, that's going to require constitutional change. And by the way, saying that, that's very daunting. One of the things we have to realize is that it's very, very difficult to change the Constitution. And in fact, that is one of its unattractive features. It shouldn't be easy to change. Okay, I understand that. But it should not be as difficult as it is. To go back to your earlier thing about, justices. Listen, I work for a great justice. I work for the great Thurgood Marshall, Mr. Civil Rights. I revere Thurgood Marshall. Should a person like Thurgood Marshall have life tenure? In my view, no. Do I think that there's something strong, good, wise about, an independent judiciary? Yeah. But, 12 years, 15 years, that'll do it. The idea of life tenure, the fact of the matter is some of the justices, and I'm not being partisan here. I'm not being partisan at all. Some of the justices, after they've been on there for a certain period of years, yeah, they don't, they've lost touch with what's going on in society, with technological change. It's not their fault. It's not that they're bad people, but we need change. We need to rethink our constitutional arrangement. And like I said, it's imperative that we do so if we want to engage in any of the changes that we're talking about.
Nan Aaron, Jordan Weltman asks, how successful was Mitch McConnell's effort to convince older judges to retire? And how many more new judges can we expect in the lame duck in this interregnum that we're in right now?
Well, he's right. Mitch McConnell worked the phones, calling judges all over the country, asking them to step down. Not sure he was that successful. As a matter of fact, judges hate being asked that question. They resent it. However, I do know that many, many judges have been holding on to their seats with their last dying breaths, so that they can either take senior status in 2021 or retire. Many of them have wanted to retire during the Trump administration and have simply, and in my view, they're heroes, held on, kept on judging. But there will be, for the new administration, I think 100 vacancies, beginning in or during the course. There are usually about 50 a year, but I think we're going to see many, many more, given the fact that we will see many judges stepping down. And there's one other factor to consider, and that is a lot of the judges, and not just the Democratic appointees, but Republicans as well, don't like serving with some of the Trump judges. These were not your stellar appointments. Many of them were unqualified, didn't even meet the ABA's very weak standards of review, in my mind. So judging, particularly on these circuits, has become really difficult when they look around and see some of the Trump appointees. It weakens, it reduces the awesomeness of what they're there to do, which is do justice.
John, can I hop in?
Sure, of course.
Really quickly. So just I want to cable the question and what Nan said. Yeah, there are probably going to be 100 vacancies over the course of the next 2 years. And if Mitch McConnell controls the Senate, he will block them all. He will not allow Biden to put a person on the circuit court, and certainly won't allow Biden to put anybody in the Supreme Court should, God forbid, Stephen Breyer, who's 82, drop dead at some point in the next 2 years. So to answer the question, what do we do about that? My question, I'll throw that question back to the questioner. How much are you willing to go with me to burn this thing down? Because it seems to me that if McConnell will not do his senatorial duty of advice and consent for a Biden nominee, then that nominee should show the hell up at court, sit down in his seat, and wait for the police to take them out. Because that's what I would do. That's what I would have done with Merrick Garland. At the point where McConnell was blocking the whole thing, I would have told Merrick Garland to show up for work, and then somebody sue to get him off the court, and then he gets to, because people have to remember, the courts have a lot of power. They don't got no army, they don't got no money. And at some point, we have to, I think Democrats, people who are asking about reform, people who are progressive and willing to really think, as Professor Kennedy said, outside the box, at some point, the left has to start viewing McConnell's courts as illegitimate and taking that illegitimacy to its logical conclusion. So if they're going to play this game, we got to start playing our own version of constitutional hardball.
Nan Aaron, what do you say to that?
No, she can't. That's not fair.
No, I'm not. I'm not trying to put her in a difficult place. I think Nan might believe that you could get a few appointments through.
I do. I do think we will get appointments through. I think this comes down to a lesson Republicans have learned: power. And I think Ellie is kind of getting at that power and the need for it. And I do think at this particular moment in time, we've got to seize it. We've got to organize. We've got to push. We have to let our senators know we're going to hold them accountable if they don't stand up on this issue. And equally important, this can't be an issue that takes a backseat to everything else. We've got to make sure on day one, along with this horrific pandemic and a very difficult economy, that this administration is filling seats and pushing hard and letting McConnell know this is of critical importance to the country and to our courts. I think we can do it.
And we've just got a couple minutes and so many good questions. I want to go back to Professor Kennedy with a question from Lori Falco. And she writes, it's my understanding that the Supreme Court derives much of its enormous power through judicial review, which is not in the Constitution. This is a power the court awarded itself early in our history. Since the basis for this power is not so solid, is there any way it could be reduced or eliminated?
Well, it is very solid. There was a decision made. It's not as if it has to be, but as a matter of history and more importantly, just as a matter of practice, it exists. I think that it has a wide and deep and fervent constituency. I think, frankly, the judicial review is bipartisan. It's not going to go anywhere. I think it's a deeply entrenched part of the system. But I do think that from the questioner, I applaud the questioner asking the question. And I'm saying as a descriptive matter, it is deeply entrenched right now. But should we be thinking about it? What do we want the courts to do? How do we want the courts to act? I think that question ought to be on the floor, on the table. What has happened in our country is so profound and so disturbing that we really do need to be radical. We really do need to drill deep and think about everything. Now, while I've got the floor, and one more line on the question of realism and thinking about the courts, and here I want to accentuate something that Nan Aaron said. again, you and your organization have done such wonderful work. I think it was really too bad that there was not more attention to the records of some of the Trump judges. You are absolutely correct. Some of the people that are now on the bench, the people who are supposed to be the arbiters of our constitutional system, the ignorance of some of these people who are now judges was absolutely scandalous. They ought not to have been put on the bench, and I think that there needs to be much more attention played. There needs to be much more attention to just basic. What do you know? Forget about trying to ask any trick questions. Forget about the trick question. Do you know the rudiments of the American legal system? Do you know enough to be deferred to as a judge? And some of the people who have been put on the bench in the last few years, the answer is clearly no. And I'll add one other thing with respect to, you talked about strategic retirement. In our own camp, one of the saddest things that happened in our own, in our own time was the failure of Ruth Bader Ginsburg to retire when she should have, the failure of Stephen Reinhardt to retire when he should have. We all need to be just more realistic.
The argument for realism gets us to the realism of the clock, and we are wound down in our conversation. I'm going to take a moderator's prerogative here and ask you the most brutal question of all, and it's just a name from each of you. If you had the chance we'll say in Ellie's expanded court, who would you put on the United States Supreme Court? I'll start by saying I'd put Russ Feingold there. The former senator from Wisconsin, who I would love to see on the high court. But Nan Aaron, who would you put on the Supreme Court if you had a chance?
Joe Biden has said he's going to put his first appointee will be a Black woman. And we have collected resumes and lengthy reports on 10 amazing Black lawyers and judges, any of whom we'd love to see on the Supreme Court. And I'm not going to say their name because the minute I do, they'll be attacked by some right-wing group. But there are some amazing Black women who will make great justices.
I like that. Professor Kennedy.
I'm sure that there are wonderful people on that list. I'm sure there are others. For me, Brian Stevenson.
Excellent. Ellie Mistal.
Christina Swarns, she's the director of the Innocence Project, and I think it'd be great to have a justice whose background is freeing people as opposed to incarcerating people.
Fantastic answers. And because I'm the moderator, I get 2 picks. I'm putting Patricia Williams on as well. And because of her ties to the nation. Thank you so much to Nan Aaron, to Professor Randall Kennedy, to Ellie Mistal, and to Congressman Jamie Raskin, who had to leave a little bit early, for joining us on this panel. I couldn't have been blessed with a better group of people to talk about this, and I thank you. With that, I turn it over to Sarah Burke, who will lead us into the next stage of the Nation Festival.
Yes, thank you, John. Thank you, everybody. It's been an awesome morning so far. We're just getting started. So we are going to take a 45-minute networking break. So everybody should head over to the sessions area now. You should see a bunch of different breakout rooms open. We have a US politics room, a climate change room, a gun control, healthcare. So find Supreme Court. So find a room that speaks to you and enter and hit the red button when you enter to turn on your audio and video so that you can chat with other members of your group. We just ask that you mute yourself when you're not talking to help try to limit any background noise. And all of you that have backstage
Paul, can you turn
passes,
this down on the
you
green?
will also see the fireside chat room should be at the very top of the session. So please head there now. I will meet you there with a few members of this panel and some others. So head over and I will see you on the other side. And we will be back live on stage at 1 o'clock with Robert Reich.
Thank you.